Hi, this is Amar, and welcome back. And today we're doing conversations with Jennifer. Jennifer's an estate planning attorney. In our previous video, we went into details of the differences between a revocable and an irrevocable trust. And today we're going to talk about what if you have to make changes to an irrevocable trust, or how do you make changes to an irrevocable trust?
Yeah, so this is a common topic that I run into with clients where they create or created an irrevocable trust years ago, and the situation's changed. And that's always kind of the tricky piece with irrevocable trust is it's much more difficult to make changes to those provisions. And it's also important to figure out who do you need to be involved in order to make certain changes to these types of trusts. And so in my practice, there's generally three different ways that we see these trusts being changed. One is there some sort of power inside the trust that's given to someone, either the beneficiary, the trustee, or the person who created the trust. Also, sometimes we see a trust protector. So sometimes there's language right inside the trust that allows someone to make changes to the provisions. The trust protector concept is becoming more and more common here in California. And that would be a scenario where you give someone the ability to make certain changes, and that's all defined inside the trust. So sometimes we'll see it right in the trust document where you can make certain changes, but it's still considered an irrevocable trust, and you still get all the insulation and protection that you would normally get with an irrevocable trust. So that's one way. There's just a power or someone right inside the trust who can make changes. The second is we go to the modification statutes here in California under the probate code. And those statutes allow modifications, which is different from an amendment, but it's essentially a way to make a change to an irrevocable trust that is consented to. If the person creating the trust is still alive, they need to consent to it, and the beneficiaries need to consent to it. And as long as everyone is in agreement as far as what the change is going to be, you can make that happen. Court's not involved, and there's no really third parties involved in that scenario. That's only though if the settlor or trustor or the person who created the trust is still alive. So if we're in a scenario where that person has passed away and we want to make a modification, then you need to look to the court and petition the court essentially to approve a modification. In those scenarios, it's always better to get the beneficiary's consent, but we don't necessarily need it. Whereas in that earlier example about modification, you do need all of the beneficiaries to consent. But you go to court, file a petition, and you get the court to approve it. There are certain parameters and restrictions that the judge is always going to look at to see whether or not a modification is appropriate. And, I would say, my practice is not litigation oriented. I try and do my best to avoid having
it.
court. And then you're dealing with the judge. You don't know which way the judge is going to go. So, that's not always an ideal situation, but we have used that in the past. In order to get a trust modified. And it's just everyone feels better about it and you get the court approval. And then the final way that we will see the ability to make changes to an irrevocable trust is known as decanting. And so any of you who are familiar with wine and drinking wine, it's a very, very similar concept. So with wine, you have wine in one bottle, and you're pouring that wine into another vessel or container, and that's going to change how the wine tastes, essentially. So you're decanting wine. With trust, it's very similar. You have trust and assets that are in one sort of document or agreement or structure, and you're essentially taking those assets out and putting them in a new trust that has different provisions in place. Certain states like Delaware, they were really, they caught on to this decanting statute really early on, and they've really kind of paved the way. California is newer to it, and I would say California's decanting statute is relatively restrictive as far as, kind of the big or the changes that you can make on irrevocable trusts. But the good thing about decanting is that is done by the trustee. So court's not typically involved, and you don't even need beneficiaries to consent to decanting. It's really just the trustee who makes that decision. It's always better to have everyone in agreement. But again, these statutes are relatively restrictive. It's very difficult to change a beneficiary's interest or to change a beneficiary on an irrevocable trust. But it's a great way to change, for example, certain administrative powers or provisions that you see where really it's not impacting anyone's beneficial interest. You're not taking anything away from anyone and giving it to someone else. So it's more, again, administrative. What are the various powers? Can you switch jurisdictions? Can you go to a different state? Those provisions you can put in either through a modification or a decanting statute. But again, they're relatively limited here in California. So again, those are essentially, the three main ways that you can change an irrevocable trust. And I'd say for the most part, it tends to be more geared towards powers. So what powers and provisions are included in these trusts, and successor trustees. So again, anytime you're trying to change a beneficiary's either when they get the asset, that's a really common thing. I meet with clients all the time and they say, well, I don't want my child to get it at age 30. Well, how are we going to change that? Because it's in an irrevocable trust that you created. And we either someone in the document has the ability to make the change, which is not too terribly common. Beneficiary has to consent to it. And which beneficiary is going to consent to, keeping their assets in a trust structure when instead they could get it at age 30. You go to court, and people don't like going to court, or you attempt decanting. But again, decanting, you normally cannot do you normally can't decant when you're taking away something from a beneficiary.
Yeah, it's hard to change like the benefits of that trust.
Correct.
For the beneficial owner.
Correct.
So yeah, this is good. So, I mean, a lot of people that I come across, sometimes they started these trusts like decades ago.
Mm-hmm.
And then now they're faced with like, oh, this is what it means in terms, and they're looking at ways to adjust that. So it's good to note that there are options. And you have to figure out the options that make most sense for those trust documents and your situation. And it's probably really important to go see somebody that knows what they're doing about this. So if you have any questions or concerns, please reach out to Jennifer or myself. And if you have any questions, please leave it in the comments below. Thank you.
Thanks.